You became a United States citizen. You went through the interviews, the background checks, the oath ceremony. You thought that chapter was closed, permanent, protected, final. I need you to stop and listen to what I'm about to tell you, because right now, in 2026, the U.S. government is running a federal operation. It has a name, it has a budget, it has a quota, and it is specifically designed to go back and re-examine whether people who are already naturalized citizens should still be citizens. This is not speculation. This is not a rumor. The Department of Homeland Security has published this. The numbers are in official government reports, and there are 3 specific groups who are at the highest risk right now in 2026. If you fall into even one of these groups, or if someone you love does, you need to watch this entire video, because what I'm going to break down for you today could be the most important 12 minutes you spend this year. My name is Raymond Crivello. I'm a senior immigration analyst and consultant, and on this channel I break down complex immigration developments into clear, fact-based analysis you can actually understand. I am not your attorney, and this content is for educational and informational purposes only. Always consult with a licensed immigration attorney about your specific case. What I do here is give you the facts, the context, and the framework, so that when you do speak to a legal professional, you already know what questions to ask. On this channel, we don't do fear, we don't do rumor, we do policy, we do data. And today, we are going deep on Operation Twin Shield. Stay with me. This is going to matter. Let me give you the foundation first, because if you don't understand what Operation Twin Shield is, nothing else I'm about to say will make sense. Operation Twin Shield began in September 2025 in the Minneapolis-St. Paul metro area. That is where it was first launched. And if you're wondering why Minneapolis specifically, that area has one of the largest concentrations of refugee and immigrant communities in the entire United States. It was not chosen by accident. Now fast forward to 2026. The operation is no longer just in Minnesota, it has gone nationwide. On February 24, 2026, DHS Secretary Kristi Noem released the official State of DHS 2026 report. In that report, Operation Twin Shield was cited directly, and Secretary Noem framed it under what she called restoring integrity to the immigration system. Here are the numbers directly from the DHS report. More than 1,000 cases were flagged and reviewed. More than 2,000 on-site visits were conducted. Those numbers are not small. And here's the statistic that stopped many immigration professionals in their tracks. USCIS officially claimed that in the interviews and investigations conducted under Operation Twin Shield, 44%, nearly half, of all cases reviewed showed indicators of fraud or non-compliance. That is an extraordinarily high number, and it has significant implications for what comes next. But here's where this becomes critical, because fraud in immigration law is not always what you think it is. When the government uses the word fraud in the context of immigration status, it can include things like a minor inconsistency on an old form. It can include an address that was reported differently years apart. It can include a language barrier that caused a misunderstanding during an interview. It does not always mean deliberate deception, but legally, it can still carry the same consequences. And that brings us to the 3 groups who are most at risk right now. Group 1 is what I want to call the technical fraud category. And this is the group that surprises people the most, because these are people who went through the full naturalization process, passed everything, and took the oath. They have been U.S. citizens, in some cases, for years or even decades. So how do you lose citizenship you already have? Through a legal process called denaturalization. And in 2026, this process has been dramatically escalated. Here is the data. The Department of Justice and USCIS have now set a formal monthly referral quota for denaturalization cases. The target is 100 to 200 denaturalization case referrals per month. Let me put that in context for you. In previous years, the total number of denaturalization cases across an entire year was in the single digits to low double digits. We are now looking at a 10-fold increase in enforcement activity. The legal authority for this comes from Section 340 of the Immigration and Nationality Act, the INA, which allows the government to revoke naturalization if it was illegally procured or procured by concealment of a material fact or by willful misrepresentation. Now, the phrase material fact is doing a tremendous amount of legal work in that sentence. A material fact can be something like a prior arrest that was not disclosed, a prior deportation order, a prior marriage that was not mentioned, even in some cases a prior address or employer that was omitted from paperwork. This is what many naturalized citizens are misunderstanding right now. They believe that once you're a citizen, you're protected in a way that is nearly permanent. And under normal circumstances, that is largely true. But when the government can demonstrate that the underlying naturalization process was tainted by a material omission, even if that omission was not intentional, the legal pathway to denaturalization exists. And right now, the government is actively looking for cases to pursue. Let me give you a real example of how serious this has become. On February 24, 2026, the same day as the DHS report, a federal judge in North Carolina issued an order revoking the citizenship of an individual who had naturalized and ordering that person to be deported. The charge was fraudulent naturalization. That case moved through the legal system and it resulted in citizenship revocation. And just 4 days before that, on February 20th, 2026, the DOJ filed a civil denaturalization complaint against a former mayor of North Miami, a former elected official in the United States, facing the loss of citizenship. These are not isolated cases anymore. This is a pattern. Group 2 is refugees and asylees, specifically those who came through the system and later adjusted status and naturalized. And there is a specific sub-operation within Twin Shield that targets this population. It's called Operation PARRIS. Here's what we know. In Minnesota alone, 5,600 refugee cases are currently being re-examined under Operation PARRIS. The operation uses the fraud and non-compliance data collected during Twin Shield to identify individuals whose original asylum or refugee claims may have contained inconsistencies. Now, here is something critically important for this group to understand. The legal standards for refugees and asylees are different from other immigration categories. When a person is granted asylum or refugee status, the initial adjudication is based on a narrative of persecution, fear, and circumstances in a foreign country. That narrative, by its nature, often comes from people who are traumatized, who may have incomplete documentation, who may not speak fluent English, and who may have had inconsistencies in how they told their story. Years later, sometimes a decade or more later, the government is now going back and looking at those original case files. And under a more rigorous and skeptical review standard, things that were once accepted are now being flagged. There's one detail most people in this community are missing. If you entered the United States as a refugee or asylee, and you later adjusted to a green card and then naturalized, each of those steps was built on the foundation of your original claim. If the government successfully argues that the original claim contained fraud or material misrepresentation, it can attempt to unwind every subsequent step. Green card, naturalization, all of it. That is the legal theory, and it is the theory being applied right now in 2026. For the refugee and asylee community, this is not a distant threat. It is an active federal investigation with a specific name, a specific geographic starting point, and real cases already in motion. Group 3 is perhaps the broadest, and in some ways the most unpredictable, of the three groups at risk. Beginning January 1, 2026, USCIS implemented what is being described as enhanced vetting, and in some cases outright processing holds for individuals from 39 countries designated as high risk. For people from these countries who are currently in the naturalization process or whose benefits applications are pending, there are additional delays, additional documentation requirements, and in some cases, a formal hold on adjudication. The 39-country designation is not just about naturalization. It impacts benefits renewals, adjustment of status applications, and other immigration benefit filings. This means that even people who are already lawful permanent residents, green card holders from these countries, may face unexpected delays or complications in their applications. Now, which countries are on this list? The official USCIS documentation references countries with elevated rates of document fraud, diplomatic non-cooperation with removals, and security concerns. Many of the countries on the list are in Africa, the Middle East, Central Asia, and parts of Latin America. This could affect you even if you're not in a visa category you think is targeted, because here's the reality. Even if you, personally, have done everything right, if you are from one of these 39 countries, your file is now subject to an additional layer of review. Your processing times will likely be longer. Your documentation requirements may be more stringent. And if there is anything in your file, any inconsistency, any gap, any question, it is far more likely to be flagged under this heightened scrutiny standard than it would have been 18 months ago. That is the environment we are operating in right now. I want to tell you about a hypothetical, but it is built entirely from real circumstances I have seen in this space. Imagine a woman. Let's call her Amara. She came to the United States from East Africa in 2009 as a refugee, fleeing political persecution. She went through the process. She was granted asylum. She adjusted to a green card in 2014. She studied, she worked, she raised 2 children who were born here. In 2019, she naturalized. She took the oath. She cried. Her kids were there. Now it is 2026, and she receives a notice that her original asylum file from 2009 is being re-examined under Operation PARRIS. The government has flagged a discrepancy between a statement she made in her original asylum interview and a document that has since been retrieved from her country of origin. Amara doesn't remember the exact wording from an interview she gave 17 years ago when she was terrified and working through a translator. Her attorney at the time has since retired. The records are incomplete. She is not a criminal. She is not a fraud. But she is now in a legal process that could, if it goes badly, put her citizenship at risk. That is the reality of what Operation Twin Shield means for real people. And that is why you need to take this seriously. Not with panic, but with preparation. So what do? Here is your concrete action plan. 5 steps. Write these down. Step 1. Locate and secure every immigration document you have ever received. I mean everything. Your original visa, your I-94, your approval notices, your naturalization certificate, your asylum approval if applicable, your original petition receipts. Put them in a secure folder, digital and physical. If you cannot locate documents, request copies from USCIS immediately using the appropriate Freedom of Information Act or FOIA request process. Step 2. Review your immigration history for any inconsistencies. Think back. Were there any addresses, employers, travel trips, relationships, or legal events that you may not have disclosed fully on a prior immigration form? You don't need to panic, but you do need to know your own file before the government does. Step 3. If you are from one of the 39 designated high-risk countries, or if you entered as a refugee or asylee, consult with a licensed immigration attorney now, not when you receive a notice. Proactive legal consultation is far more effective and far less expensive than reactive crisis management. Step 4. Avoid common traps. Immigration scams are surging right now. Notarios, visa consultants, and unlicensed practitioners who claim they can protect your case are not your allies. Only a licensed immigration attorney or accredited representative can provide legal advice. Verify credentials before giving anyone your documents or your money. Step 5. Monitor official USCIS and DHS channels for updates. The policy environment is shifting rapidly. Checking USCIS.gov and the DHS website directly, not secondhand social media accounts, is how you get accurate information. Let me step back for a moment and give you the larger picture. What we are seeing in 2026 is not simply one operation or one executive action. It is a coordinated policy posture. The Trump administration has made immigration enforcement, including denaturalization, a formal institutional priority. That means agency resources, staffing, and referral quotas are all being directed toward these cases. This is not a temporary surge. It is a structural shift in how USCIS and DOJ are allocating resources. Will there be legal challenges? Absolutely. Several civil liberties organizations have already raised concerns about due process, about the application of old standards to old cases, and about the potential targeting of specific national origin groups. Federal courts will likely hear significant litigation on some of these issues in the months ahead. However, this protection may not be permanent, and court timelines are long. What that means practically is this: even if a court ultimately limits certain aspects of these operations, the process of being investigated, interviewed, and potentially named in a denaturalization action is itself costly, stressful, and disruptive. The time to prepare is now, not after a notice arrives. I want to be direct with you before I close. Your immigration status is not just a legal technicality. It is the foundation of your life in this country. It determines whether you can stay with your family or be separated from them. It determines whether you can keep your job, your professional license, your financial accounts. It determines the stability of everything you have built. The people affected by operations like Twin Shield are not abstractions. They are parents, professionals, community members, and taxpayers who played by the rules and built their lives here in good faith. The legal system has mechanisms for challenging unjust actions, but those mechanisms require preparation, documentation, and legal counsel. Do not assume your case is safe simply because you believe you did everything right. Verify it, document it, protect it. If you want accurate, fast, and reliable immigration updates, subscribe to Raymond Crivello right now and turn on notifications. Immigration policy is changing rapidly, and staying informed is no longer optional, it's essential. If this video helped you understand something that felt confusing before, I'd ask you to do 3 things right now. First, leave a comment below and tell me your visa category or immigration situation. I read these and I use them to decide what topics to cover next. Second, share this video with someone in your family or community who needs to hear this. One share could change someone's situation. And third, hit the like button. It tells the algorithm that factual, responsible immigration content matters. It helps this information reach the people who need it most. This is Raymond Crivello. Stay informed, stay prepared. I'll see you in the next one.